Alright, hello and welcome to A Questioning Mind. I'm your host Sagarika, and today I have the pleasure of being joined again by Abhivardhan. Namaste Abhivardhan and welcome. Abhivardhan is a lawyer, and we've spent quite a lot of time offline talking about several of the issues that plague the legal context in India, as well as policy frameworks that don't really work. And I'm really excited to be driving our conversations towards some of those. And Abhivardhan has also recently co-authored and published a very interesting, very insightful report into international policy, and I will have him explain and walk us through a little bit about that. It deals with a lot of terms that we use very regularly but aren't actually familiar with how they translate to the law. So that's what Abhivardhan's done with that report, but also that's what we're going to do today. We're going to discuss the basics of jurisprudence, and he's the best person to walk us through it. Abhivardhan, so first question is, I just used the word basic, okay? So first question is, in terms of the sort of abuse or overuse of the word, of the phrase basic structure doctrine, could you explain it for the audience, what it actually means and how it's applied, and if they are in sync?
First of all, Sagorika, thank you so much for this second invitation, and I would be very happy to discuss these ideas as they've emanated as far as constitutional law is concerned. So, the basic structure doctrine is something which is unique to India, that's for sure, and it is related to the idea of constitutional morality as well to some extent. But largely, it is a doctrine of bargain in a sense that the Supreme Court of India can preclude any constitutional amendment which is passed by both the houses of Parliament and even assented by the President of India, because assent ke baad hi the amendment becomes the law. Before it doesn't.
So one second. You're saying that the Supreme Court can overrule anything that is passed as law using the basic structure doctrine. So that's the application.
I am talking about a constitutional amendment. Yadi koi amendment hota hai in the Indian Constitution, if there is any amendment happening, then of course to houses of Parliament, provided that it is not equivalent to a money bill or a finance bill, वरना फिर राज्यसभा जाने की आवश्यकता ही नहीं पड़ती. They can consult it, but it doesn't matter. And we are assuming that it is like an ordinary bill, a constitutional amendment, which is not like a money bill. It goes to both of houses. Yes. The majority comes in. Now, it depends on what kind of an amendment it is, because either in one case, just making it simple, either in one case, it only goes to the two houses and the amendment is done, then go to the president, or the two houses, then all the Vidhan Sabhas across India, they also have to approve with majority, simple or absolute. And then once the majority is done, then the president assents it. Be it as it may, what generally happens is, jab ye pass ho jata hai, the Supreme Court can of course review it and state whether it is a legitimate amendment or not. Now, of course, everybody talks about basic structure these days. So, I mean, मैं जल्दी से एक hit list बता देता हूँ इसकी. The first amendment of the Indian Constitution was there. Then the cases like Golaknath versus State of Punjab, and Keshav Nanda versus Keshav Nanda Bharati versus State of Kerala in 1973. All of these cases were there. Even cases like I would say Shankari Prasad versus Union of India were also there. But the one thing which was related with the basic structure was about the power of the Parliament to amend the Constitution in such a sense that the relationship between Article 368, which is which gives the Parliament to amend the Constitution as a power, it is derived in a sense. It is allegedly derived, because it was stated in the Golaknath case. It is allegedly derived from Article 245. If we read also the Union list, which is the first list in the Indian Constitution, and if we specifically read entry 97. Right? And before the Keshav Nanda case, it was the norm कि नहीं ये तो बस एक amendment है, and that's it. But the issue was related to fundamental rights. Now, this is very interesting. because the basis of fundamental rights is contrary to popular understanding. It's not just your Article 14 and 21. The understanding of fundamental rights starts with Article 12 and 13 in that sense. But I'll say very, very specifically 13. In 13, the word law has been mentioned. So, for example, you have a pre-constitution law और a post constitution law. मतलब क्या है? संविधान के आने के पूर्व जो विधि जो कानून थे और संविधान के promulgate बोल रहा हूँ फोर्स में आने पे उसके उपयोग में आने पे जब वो which is on the Republic Day 26 January 1950 उसके पश्चात जितने कानून पारित हुए हैं वो दोनों जो कानून हैं वो उनकी legitimacy के questions होते हैं. They should not derogate any fundamental rights per se. And of course, exceptions and everything are based on court judgments. I don't wish to complicate it, therefore. Every right has its own reasonable restriction in its own way. Certain rights don't. But I think that's the way. But the interesting part comes after the Golapnath case, because in the Keshav Nanda Bharati case, that time, Justice Sikri had basically stated that there are certain elements of the Indian constitution. जैसे क्या है? The supremacy of the constitution, the very structure of the government of India and the governance in India, you know, the whole Indian polity, कि भैया republican और democratic forms of government होती हैं, parliamentary form of democracy है, ठीक है? It's a bicameral legislature, all of those kind of things. And definitely the secular character of the constitution comes in, which is derived from the preamble of the Indian constitution.
Yeah, we'll come to that.
Yeah, and then also things like separation of powers doctrine, which is between the parliament, the executive branch of the government, and the collegium, which is the judiciary in that sense. So people also say that fundamental rights तो है ही है salient feature of a basic structure, लेकिन उसके अलावा there are other judges who also stated कि जो DPSP का mandate होता है for creating a welfare state for people who have been affected and all of those economically and otherwise due to discrimination, etc., वो भी एक चीज है. You know, maintenance of the unity and integrity.
So just to clarify, okay, there's been a lot of precedents we're discussing and a lot of older cases, etc., which is precedent. But so my question is this a little more arbitrary, or is there a framework that we determine this by? Because today the usage of basic structure is something that I have not seen as much in prior decades. So is there a framework refer to?
That's a good question. First of all, I think the doctrine has not been effectively used by the Honorable Court for now. अभी तक ऐसा कोई बहुत major use नहीं हुआ है. The interesting part of the basic structure doctrine, however, is that there are many discussions happening around it in various circles and events and whatnot. Now, for me, it might not matter much simply because implementation is something which I'm more focused on. But still, let's see those discussions a little bit. So the one funny thing which happens with this doctrine is I agree that the judiciary should have certain basic control over certain things to at least determine कि भाई parliament policy doesn't go in vain, because the rationale behind at that time to come up with such a doctrine was to basically prevent the government under Prime Minister Indira Gandhi to do certain things which were arbitrary in nature. So many things
like
were arbitrary in nature. Yeah. Glorifying the preamble तो बाद में हुआ है वो तो modify में भी देख लीजिए. When you added secular and socialist, it doesn't violate the basic structure actually, because socialist means welfare and secular has to do with the secular character which the Supreme Court has been defending always, which is why it was added according to the
Mahasabha constitution had that. The state, the power. However, our constitution is not a secular constitution. Until we keep an associative nature with the preamble, our constitution is not a secular constitution. It has a personal law and it has a particular, it treats a majority religion as something to sort of control and judge, which is
that is
right
something
at this point,
I'll
that
say
is validated by a
correct.
constitution. So there is no separation of power in that. So there is no separation of church and state or temple and state in this case. So
Correct.
it's only
Correct.
through association with a preamble that we have that.
Okay. Okay. So let me clarify on that interestingly, since you raised so many interesting points. If you want to go to the Indian Independence Act of 1947, which is the funniest thing to start with, dominion status ka issue hota hai India and Pakistan. We know that. And yes, the British stated that, people who are Hindu majority will form India, people who will go demography wise, Muslim majority voting, they will go for Pakistan. Many princely states chose neither. We know why. And then Sardar Vallabhbhai Patel united all of those, as many as possible, to India, including the Portuguese and the Hyderabad Nizam.
Sure.
Now, वहां से अगर rational लेते हैं, then we'll say that a constitution, like, I know that my Twitter friend Ruchir Sharma regularly says it is a Hindu reformist state, India, which I might agree with. I'm just saying that maybe in the Constituent Assembly also, we did not go for such terms or such a, direct understanding, which is why we were very confused for a long time, even since Pandit Jawaharlal Nehru. Otherwise, Nehru would have brought the amendment in the preamble. It doesn't matter anyway. So I think it has to do with the thing that whether secular or not is a different question altogether, because I have to look at it, the Constituent Assembly debates in general, but I am specifically of the view that it is not estimated properly. I'll tell you why. It's simply not estimated properly because people just do not even realize what are they proposing for, and that was a predicament with many of the 20th century freedom, quote unquote, freedom fighters and leaders of that time, including Patel, Nehru, and Ambedkar. This is why when this when this amendment in the preamble was done, it was done for symbolic reasons, but also to please certain sections in Indian politics, blah blah blah. But that is why the basic structure is a politico-legal tool, in my opinion. I've written an article with my friend Vaibhav Dwivedi, which is available on industthink.medium.com, and you can read it on the basic structure that it is a doctrine which is a politico-legal doctrine. It's not just a legal doctrine, because somewhere down the line the Supreme Court is involving in political affairs, because ये थोड़ा सा political हो ही गया ना कि amending power में कहीं ना कहीं आप कुछ character define कर दे रहे हो. Now, of course, the question will come in whether it is arbitrary or not. It's both. It's neither arbitrary and it is arbitrary. Why? Neither arbitrary to tab hoga when it's a question of subverting the status quo, which on policy aspects makes sense, but arbitrary ho sakta hai when the executive wishes to shape the constitutional system in its own way by the assent of the parliament. So if we say that the parliament intends to reform the system of parliamentary democracy and other things, or give more powers to the President of India, or maybe change the way the Prime Minister works, the Parliament can do so. If a government or a private member bill is really passed by a majority, it's a decision of the Parliament, then it's fine. But as you stated, there's no separation of power. I have a different outlook to it. I'll tell you why. Separation of powers is possible in a country where distinctiveness is basically visible. Dr. Abhishek Manu Singhvi, who is a lawyer, senior advocate, and a politician from a particular party I don't wish to talk about, he actually argued in a case related to the PMLA Act, which is very interesting. One point he raised, and it is already reported by portals like Live Law and others, very, very interesting. He stated that when Montesquieu went to Africa, America, when he went to America, he was a French, he created this idea of separation of power, separation between three organs or two organs of government, it depends. But our inspiration came from where? The Westminster system in United Kingdom, correct? Interestingly, the Privy Council in the House of Lords used to handle judicial matters. And the House of Commons was more democratic because it had direct representation from the counties and constituencies in UK, as it has today. House of Lords is less powerful, but it has some certain strategic value because it has the people who are designated as lords and ladies by the the UK's Majesty, that is a UK Queen. Now, or king as it may be in future, we don't know. But one interesting thing which we can learn from is that the UK Supreme Court came long in the 1990s. It never existed after even during the Cold War era. It was near the time when the Cold War era ended. I think maybe after or before Margaret Thatcher, maybe during Tony Blair. I'm not sure about it, but I think it was at that time which it came. Why?
Wow.
Is because they wanted, of course, to do some legal reforms. But if we take some inspiration from there and understand how it happens in India, see, India, when the colonial era was there, the British Raj, we had tried to create a system of separation of powers in our own way, and we have to recognize this, whether we agree or not. The politicians of Congress were very much representing the larger Indian
Sure.
voters in those elections.
Yes.
So that time,
Yes.
that's a different issue that the Congress went, in a sense, which was something unacceptable. But
Sure.
at the time, Gopal Krishna Gokhale and all of these politicians had that value.
Yes.
Now, what interestingly happens is that all of these legal recourses, like the Supreme Court of India was inspired by the High Court of Judicature in Kolkata, which is Calcutta, because Calcutta was the capital of the British Raj. Then it shifted to Delhi after the Delhi, once the Delhi Darbar thing happened, and the
1919, yes.
Jana anthem was basically. So at that time, I think it was very obvious to observe that separation of powers was tried to be created as an idea within colonial India. But in a modern India, once partition happened and the 1949 constitution came into being, people always say 1950 constitution. No, it is the 1949 constitution, because it was agreed upon on 1949.
Yes, it came into effect on the 26th of, yes, but it was on the 26th of November 1949, I think, that it was actually published.
No. 26th of November 1949 accepted, 26th January 1950 put in force. Now you go ahead.
Put in force, exactly. All right,
Yeah.
I'm just going to summarize this for my viewers and sort of simplify
Definitely.
it. The case
Definitely.
argued in regards to separation of powers is not based, apparently, according to a precedent, it's not based in the French Montesquieu's understanding in the American context of the American Constitution of separation of the 2 or 3 organs of the state, whether it's legislature, executive, and judiciary, which was clarified in the American Constitution. Ours instead is based on the UK Constitution, which mixes up a little bit, where the legislature has power over the judiciary in sort of legalizing or criminalizing certain aspects.
Yeah.
Both houses have a certain bit of power vested. Now, what I understand is that in India, it is almost the opposite, because we've gotten to a constitution worshipping and even a civic nationalism that worships the constitutional,
yeah. So just one thing to add. So Dr. Singh argued it in the Delhi High Court, I think, or the Supreme Court, I don't remember, one of the courts, very interestingly argues, and the report might be wrong, so live law can be blamed for it, quote unquote. Sure. But what he argued was that India does not have an institutional understanding of separation of powers, but it has a doctrinal understanding. Ab ye bada interesting hai. Kaise? When you say institutional, then it is what it is. You just can't change it. But when you say doctrinal aspect of separation of powers, it gets very interesting. You are saying that you are actually using it as a piecemeal approach and not an institutional approach. So, you can find many judgments. The Supreme Court saying we are not the state. You will find a judgment where BCCI was declared that it was not a part of the Indian state. That is how BCCI quote unquote privatized, and the commercial whole engagement of IPL etc. happened properly, because the BCCI got a lot of autonomy in that sense. But otherwise, the BCCI would have been a statutory body like the Bar Council or the Olympic Federation of India. The Indian Olympic Federation, something like that. I can't remember the title. So statutory body nahi thi, right? So क्या होता है in India? We have a piecemeal approach to separation of powers. This is why it was never a legal provision in the constitution. It was a provision as a suggestion in the directive principles. I think Article 50 or 51.
Yes.
So that is why it is doctrinal. Now, of course, out of good faith, as we say in law, and that gesture, courts will say we have separation of powers and independence of the judiciary. And that the same will say for parliament and others. But koi institutional guarantee nahi hai. Till now, there is no institutional guarantee, and this is how such complications are created.
Is that an established fact, or is that something that the courts will, that the judiciary will simply not create a precedent because of the arbitrariness of it. Because, they can very well say that we will institutionalize it, or it is institutionalized. There is no reason for us to take the UK approach instead of the American approach, right? So they're not creating a precedent.
Right. Now, if you see the UK, now they have separation of powers because the UK Supreme Court is very independent. The House of Lords has very limited power left. Under David Cameron and even under Theresa May and Boris Johnson, that power has gone even down. So David Cameron was so radical, he was saying, I'll just disband the House of Lords. It never happened because of Brexit and other things, with the referendum of Brexit. And he had to lose power because he promised that he would support the UK staying in the EU. Now, interestingly, if you're saying that it can be a guarantee of something which can the court state, well, the court, if you go to the court will always stay. The honorable judges might state that according to the basic structure judgments, separation of powers is not is something which is deep within our constitutional values, etc. So they will always state that, which is their own self understanding of the whole system, particularly how the judiciary sees it, right? So the system sees that way because it wants to. But again, there's no institutionalization here. Unless there is a proper amendment which says that, the legal recognition of separation of powers is done, then it will be more interesting. But yes, it also doesn't mean that separate systems nahi hai. It simply means that since it's a doctrine thing, it's not an institutional thing, to make it simple for people. Hota kya hai that you can create certain loopholes. Now, that is why our understanding of separation of powers has not even matured with time. हम समझ ही नहीं पा रहे है क्या separation of powers, and this is why
I think it's a much more recent phenomenon. Even when we were studying, like, I'm pretty sure you and I, we've gone through the education system and NCERT books, ensured that it was inculcated that there are 3 different organs functioning on 3 different aspects of nation state. So I think it's the literature around, the kind of modified literature around, especially that's picked up in the last 10 years, that has sort of pushed these ideas and made it much more arbitrary than it used to be. So
yes. It can. In fact, there's a research by, I think, TISS or somebody, I don't know, Vidhi ka research, the Vidhi Legal Center for Legal Policy, which shows that the moral capital of the Supreme Court has gone high. People trust the Supreme Court more. I mean, it was in 2018 or 2019. Abhi kitna hai? I'm not going to state about that. Us samay it was very high.
I also know that even prior to 2018, I think if we go back to 2013 or 2012, I think we can see that same trust being reflected, because I remember several judgments, and it was always the Supreme Court whose judgment, was accepted without any sort of protest, and it was more in line with the democratic nature of our nation. But right now, is there an overreach with suo motu recognition by high courts as well as the Supreme Court of issues, whereas there are over 4 crore cases that are pending, including criminal, extremely important criminal cases, as well as, the issue of justice being delayed is equal to justice being denied, which is very often the case, considering that, just for the views, I'm just going to state a few examples. I realize that you and I will not be talking about criminal law as much, but in India, over 90% of the rape convicts walk free after 1 year if they are arrested at all. And this is because there is a lack of implementation of law in certain cases. They are not dealt with, dealt to either the full extent of the law, or there is insufficient evidence. So it's not the judiciary's fault as such. It's just it's a systemic error in this case. And also, most of them turn out to be serial rapists. So that said, there are crores of cases that are pending in business in criminal cases. There's, of course, there are amendments being made. There are statutory bodies, the Insolvency and Bankruptcy Code that has been brought in, and all of these measures to protect certain interests are being, thought of right now. However, the courts themselves have a lot of backlog, and within that we still see a lot of suo motu recognition of topics that should typically with separation of power, be left to the legislature or at this point and enforced by the executive, which or is that something that we see particularly in India?
That's really interesting. Let's talk about suo motu. Okay. So suo motu क्या होता है? मान लीजिए कोई मुद्दा है, quote unquote. I'm saying मुद्दा है, quote unquote, because you can assume anything as a issue. The honorable court, under any bench or the chief justice's bench, division bench or generally तो full bench होती है जैसे 3 judges या constitution bench which is 5 or more judges. तो फिर कॉन्स्टिट्यूशनल बेंच है तो फिर चीफ जस्टिस आ ही जाते हैं जनरली, और मे बी नॉट, आई डोंट नो, बट आई थिंक मोस्ट केसेस होता यही है. तो इन दैट केस इफ एनी इशू दे फाइंड इम्पोर्टेंट दे विल डील विद इट. जैसे कि सीजे एनवी रामना thought of pursuing the Lakhimpur Kheri case, and he took it suo motu. Request for suo motu, people can make it through PILs. Many lawyers have tried to do so, whether it is the post-poll violence in Bengal or whether it is anything. Many issues I like that. Kerala High Court also took some issue, I don't remember, about certain thing. So there are issues which are being taken. Okay. And I think that happens simply because the way it happens is about two arguments. So there was a judge called V.K. Krishna Iyer. So Justice V.K. Krishna Iyer was very popular for his welfareist judgments. And in fact, he was a great judge. He had a quality. We have to understand that the judges in the Cold War era in India, post-partition, they were really good. Of course, they had biases. I'm not saying they had none. I'm not saying that the judgments were perfect.
It's humanitarian to a large extent.
Exactly. But since the 1990s, when the PIL era started, the deterioration of the quality of judgments in India is massive, which is why you see pendency and a lot of those things, which is a problem which even the presiding officers in various courts are trying to resolve. Okay. Several people in the fraternity of law, academia, and others who talk to me, I talk to them sometimes. They tell me that one trend they see in general is that the way the whole system is being used, somewhere down the line, there's a problem because there are no nuanced cases coming anyways. They are just either polyvocal. So there's a trend of polyvocality. Even I remember one advocate from Delhi, Advocate Nikhil Mehra, who is an expert in criminal law. He's an NLSIU alumnus. He discusses about polyvocality of courts, which I very much agree with, because polyvocality is something which happens. I have discussed it in one work for GLA called a decolonial approach to the Indian Constitution and etc. One work only, and in that work I had discussed that there's a problem of polyvocality. So you pick and choose certain issues out of your interest. Whether you are justifying or not, it gives a bad impression to the public. It has certain role. I am still waiting that the Niti Aayog to come up with a report on the economic impact of judgments. That still hasn't happened yet, right? There's one institute in Delhi doing it, but karle to maza aa jayega. It would be so great to learn about, I would say.
I think there's a lot of literature that is not really compiled so far about the economic impacts, especially when it relates to manufacturing being hampered either in the Sterlite protests that happened. We have Kudankulam, that's not manufacturing, but that does give a lot of, I think there's a lot of literature out there. It's not been compiled. So it would be definitely the RA construction that was stayed. I think recently there's been a ruling that asks people to get rid of the PILs very quickly that have to do with infrastructure creation. So that is a lot of lack of knowledge, especially we know that very often due to either malintent or but mostly due to ignorance around the laws itself. And around the actual contractualized situation, people do take a lot of issues and make them sensationalize them to a general audience that is not really aware of the context of many of these concerns. So, for example, obviously, when it comes to pollution, better infrastructure would lead to lesser pollution as opposed to, higher pollution. But a few trees will have to be transplanted from their current location. And to deprive local populations of that infrastructure, causing them to live in very, very poor circumstances because a very privileged set of people will take the car through through the RA colony, which having lived close by for some time, I definitely have a lot of nostalgia around RA myself. However, to see infrastructure being delayed for such reasons is quite sad to witness. I've never come across it in any other country. It's always fitted and celebrated that we are progressing in terms of infrastructure. However, we can sensationalize an ecological aspect in this and then forget that it would actually cause less pollution. So these are things I think dependent on a lot of public imagination. So I do want to bring up one of the tweets that he wrote, and we will have to go back to Montesquieu in this case because it has to do with separation of power, and you explained it, and it really made me want to discuss that on our podcast. So this is something you said, that the separation of power is merely a legal doctrine for a post-colonial state with feudal characteristics of physical leadership. So this is something that I found very interesting, and I will probably come to this aspect a little later, but I'd love for you to explain it to us right now. Let me just bring that up for the audience.
Sure.
This is what you wrote, and I think you were speaking about Adkit Singh at that point. So
yeah.
This was the same.
Yeah. So thank you so much for showing this to me. So when I say this, you can just scroll it a little bit down if possible. But I think it's fine. I mean, I can just see it. Yeah, I have the tweet now. Thank you so much.
Sorry, were you able to view the screen, or did I bring it up on the stream? I can't.
Yeah, you did. You did.
So that's us.
Yeah, perfectly fine. It's okay. So, yeah, when I say that we do not have separation of powers, I gave my reasons, right? And as I said, it's merely a legal doctrine. So I said that it's a doctrine. It is not an institutional policy which is unquestionable. There's a difference between both.
Right. That's why it's mad.
Exactly. Now, the American Constitution was very heavily inspired by the Greco-Roman culture and the Greco-Roman form of democracy in the Roman Empire, which is Italy, and even Athens in Greece. Okay, and whether we talk about settler colonialism in America, all of that, you have to also remember that the so-called founding fathers had that conception of democracy. Now, let's come back to India. When I say that I'm saying post-colonial state, I'm saying that we are a state which came after colonization ended in Britain through a peaceful process, of course, with unpeaceful or violent repercussions across the border. And when this state was formed, we were in a situation of post-coloniality that somewhere down the line, we were being affected and we were trying to come out of the colonial policy limbo, which was affecting us. That, of course, in my view, takes time because it's not easy for a former colony to just regain power and do so. For a country like India, like other global south countries, that was a very commonsensical problem, which is fine. I mean, for some years it was okay, but we have to think better. Now, interestingly, I also say feudal characteristics of a physical leadership, which means that when it comes to physical leadership in India, it is very feudal in nature. What does it mean? The ossification of the colonial Indian polity was actually done by the British Raj, because many things which were brought forward by the British in the name of labor reforms and others, the labor laws, for example, they were never even proper implemented because of many reasons, the way politics worked in colonial India, and so forth. Now, that baggage of legacy, when you first ossify your whole economy where livelihood and everything is done, and then you go for a for a phase that you you ossify their rights in certain way. But again, I mean, for a civilization like India, I am rather going to say that my understanding of history is not so good. So, rights and duties afterwards, but let's come to the main part here. Now, you ossify a way of governance that feudalizes. Like, for example, the laws on Zamindar. They were specific tenancy reforms. They were not land reforms, which were done in the Nehruvian era. Basically, there were two reasons. एक तो करना ही था because land issues and all of them. Second, the Congress wanted to get rid of the zamindars, to strip off their economic power. Simple reason was that for the Congress to do so. They did it, and they went ahead. But they were tenancy reforms. They were not land reforms. And that what happens is the feudalization never ended in that sense. You just gave it to somebody else, and economic empowerment did not happen. That is why I said feudalization through one example. But if we say feudalization, it can happen in many other ways also, which is to say investment in R&D in India, whether it is education in India. How did you basically, which is the Indian state, use physical leadership to create a limbo that you can't even, you have your rights and you also can't just leave the state like that. So it is feudal by nature. So it's like this. Let us say, so we have startups in US and other countries which are trying to financialize services. How? $25 per month subscription for a particular XYZ service. Now that is very costly, right? 25 into 12 plus add your taxes, etc., etc. If you convert it into native currencies, or let's say domestic currencies of other countries like India and others, it will be another problem. This is the policy of financialization which startups and companies do. Now, what happens? The middle class is basically in the worst situation. Okay? The whole problem with financialization in America has been that it has reached to such a pinnacle that even companies are now saying, buy your pizza and pay it later. So now people will be paying, children and all of those people of the particular person XYZ are going to pay EMIs for pizzas. In fact, I think recent reports by a particular media show that Zomato is trying to come up with a similar policy using UPI. Now that is weird, but again, financialization, right? You create a feudal situation economically, and most trends you will find economically only. Culturally, others is a very contentious question. Not going to comment. Sure. I don't know about it. I have no knowledge of that. Economics, I definitely see a trend. Okay, and therefore, in that case, it actually becomes problematic. So people really need to look at that aspect very, very carefully. Now,
so again, to simplify so far what you've said so far is that these feudal characteristics is a colonial legacy that is now being implemented without a review of what they actually entail for the general public.
Yeah, but it has to also to do with the political economy of India, because whether it is the Green Revolution in Punjab, or whether it is a Milk Revolution, or whether it is anything else, the problems that we had in India were that the way the subaltern was treated and the way the subaltern also treated political actors in India, it was not a relationship which was properly democratic, despite the fact that people, of course, voted in everything, which was to say, which is vote bank politics. And the less we comment on it, the better, but we understand vote bank politics. That you basically create yourself as a group for only groupist purposes, and you try to create a chain of problems. That is how the license Raj laws were used. There's an excellent report being published by ORF on I don't know, jailed for doing business or something like that.
Yes, so that's an amazing report that goes into how tough it is to do business in India. And
yes,
yeah, of course, they go into where it carries forward from. I will link it in the description box below. I think Gautam Chikkermani is one of the co-authors, and I forget the name of the second co-author.
But it's Agarwal or something. Yeah.
Right. And even though we've improved our rankings and ease of doing business, there is a really long way to go. So that report gives a really good insight into it.
Exactly. Now, in India, the law and order situation has not been much better until now, until the 1990s, when we increased our police weightage,
Sure.
per square kilometer population, etc.
Okay, I have
So
a question about this. What does it take to do that? This is a little bit off the jurisprudence discussion, but what does it take to increase state capacity? It's a state issue in the it's not a concurrent issue. I think it's a state issue. So
yeah. In the case of union territories, it's a different question. And in case of state, yeah, Kashmir and Delhi are different examples. But in case of state governments, it is a state matter. Police
sure,
reforms are inevitable and needed right away, no doubt about
absolutely,
it.
absolutely.
Walk-in interviews for appointment of people into the police cadre, increasing the IPS numbers by reforming the UPSC examination in that sense. All of that is needed right away.
Is
Efficiency
there
of
a legal
training, all of
aspect
that.
to this? Is there a legal
Hmm?
aspect to this where does a law need to change to increase state capacity, especially in terms of law and order?
There would be regulations on this. There would be statutes on this. So
That's
definitely there would be state level statutes to make amendments and make changes. But I think it's not much of a legal issue, maybe because it's more of a, there's no legal lacuna to make reforms. There's a policy problem which is motivation issue. Like in Chhattisgarh, you have walk-in interviews, but in Uttar Pradesh you still don't have. And in 5 years you have the constable exams. So that's, I mean, why if somebody should waste 5 years, and you have an age limit also then? So how many times will a person give exams? You have a huge population which wants to get into police. You don't have walk-in interviews. So I'm just giving an example of UP and Chhattisgarh, but I mean in a general sense. So I mean, police reforms are inevitable. They are needed. Yeah.
All right. Now, another thing I said about the tweet that I would like to sort of reframe and ask that when we had discussed this previously offline, we came to the physical responsibility of the application of legal doctrine. So what we discussed was that anybody applying those policies or implementing those policies and passing the judgments is completely devoid of any responsibility for those judgments and how it affects the on-ground population. So that does form part of the future feudal structure that we discussed, yes?
Yes, passing of responsibility is a problem. It's like, I'll tell you a funny case. Funny and unfortunate both. So in the second wave time, at the time when second wave happened, you'll see a trend very funnily that the Uttar Pradesh government had stated to the Allahabad High Court that they don't wish to conduct the panchayat elections very early because second
Yes.
wave was very much foreseeable. Yet, what happened was the Allahabad High Court did not understand and said, do the elections right away. What happened? Many people died of COVID
Of course.
due to the Delta variant, etc., etc. And भाई जब लोग मरेंगे तो somewhere down the line the government is responsible, right? Why did you conduct the elections? But I mean, is the judiciary not even responsible for this? So I mean, I am not going to say whether they're responsible or not. That's a contentious point, but I'm saying you did something
Oh, well,
anyways, right?
speaking of the physical responsibility, right? I think there's a very recent case where a doctor who was attacked by patients, etc. He approached a bench for redressal, and he wasn't really offered much. And it was stated that it is his job to sort of save lives and take that responsibility, and be party to that disrespect of the other that was accorded to him. So he was forced to acquiesce to that sort of disrespect and even danger to life. And this is a common problem we've seen across the country where people go in and beat up doctors. However, the same judiciary has the contempt of court as a legal weapon to use against any of their dissidents or anybody they arbitrarily feel is disrespecting them. So that is a pretty, I think, pertinent example when we speak of physical responsibility for and defines the feudal characteristics that the judiciary is currently functioning with.
Yeah, I mean, with no interest of contempt towards the court. and with utmost respect that we have, in line with the Contempt of Court Act, because all of which we are speaking is a fair comment, and of course I'm saying in both joke and good faith. I generally mean is that you can basically say that certain executive policies have problem to a limited extent wherever implementation and legal issues come in. But when you directly come into policy problems that causes severe issues, then there is something wrong. I remember that a bridge was being built by the Indian Army in Uttarakhand, and some relative of one person who was stuck near the bridge, and the army created a temporary bridge for that particular individual. Some relative of the person moved to the Delhi High Court, and the Delhi High Court gave an order. I think it was single bench or what. They gave an order that that particular person must be airlifted by the army. The army junked the order completely. They said, "भाई एक व्यक्ति को क्यों हम airlift करेंगे? सबके लिए bridge बना रहा, सभी लोग आओ." So there are certain things which are irrational, and sadly, judges are also not bereft of irrationality. So, I mean, that's a very sad issue, but it is what it is. Yeah.
Right. Now a very direct question, and I'm going to put you on the spot. Are we a minoritarian state as we are accused of being?
We are a confused state. We are not a minoritarian or majoritarian, as we say. I believe both of these terms are on aspect of policies very fake and something which should not exist as terms either. When you say majoritarian, for example, you say that it is driven by the whims of the majority in the name of public morality. When you say minoritarian, it is the tyranny of the minority in certain ways, which is to say in countries, many countries it happens, certain minority groups, and I'm not saying minority in that sense every time, which is religious minorities, which everybody understands. Any minority.
We can think of South Africa in this context.
Yeah, so any minority, cultural or anything, they can try to basically create a heckler's veto situation by saying, you know what, you have to do certain things according to our understanding. Now, of course, law and order situations and other things come in with but I don't get the logic how these terms really exist, because it feels
in the legal sense. In the legal sense, are we a minority?
No, they don't. No. There's no basis. See, we are none of them. We are a confused state. I'll tell you why. Because our policy, I'll tell you why. I think the problem is, if you're saying that we help the minorities and we have, all of those schemes, and we have the problem with the Waqfs and all of that, which is reforming the Waqf Act and all of that, I agree with it. Which is to say, for example,
those are specific problems, right? Those are specific problems, and the affirmative actions do not have sunset clauses, and those are, again, we can take them as piecemeal. But as a state, as our constitution suggests, are we a minoritarian state? Because again, a lot of reform is implemented on the majority, whereas the minorities are encouraged in a lot of ways.
That is correct.
Exactly. Institutions, etc.
Yeah, so that is the policy impact which you're trying to talk about. If you're saying legally, I am just yet to see a text on it. I mean, if you're talking about interpretation and policy paralysis, I definitely agree.
That is of course there. Most of the discussion is around the policy implementation at this point.
Yeah,
which
it's like I mean, that's what I said na, bhai, agar ye yadi अच्छा होती तो secular और socialist क्यों नहीं डाला when the constitution came into being? Why was it not put before 1949? They just did not. So it's very contentious and weird. I mean, you put it in the 1970s after. I think it was done after the emergency and after the Janta government. Yeah. No, it was not done during the emergency. It was done after, I think so. Maybe. I don't remember the exact. I think 1976 or something. Okay, fine. So, main point was, I think, 42nd or 44th Amendment. Okay, one of them. I always forget that. But ironically, minoritarian wala jo problem hai, it is simply because of policy implementation. Like while the Hindu Code Bill was discussed properly, consultations did happen. The 3 acts, Hindu Marriage Act, Hindu Maintenance Act.
I think we've lost Abhivardhan.
Consultation properly.
I think we lost you there for a minute. Could you repeat yourself again? The Hindu.
Sure, definitely. While Yeah, while the Hindu code bills were definitely they were never implemented. I don't know why, but the Hindu Marriage Act and the other two acts, the Hindu Succession Act and the Hindu Adoption and Maintenance Act, they were not discussed in public. Okay, now if you compare it with other laws, of course, I'll tell you one interesting thing why this problem happens. So see, what is the structure of our state? It is a European style state, right? It is by any means a European style state. It is not an Indian state. It is a European style state. It's a parliamentary democracy based on British ideas, but it has certain French ideas and other ideas, right? Second, when it comes to Abrahamic religions like Islam, Judaism, and Christianity, the understanding of law is very easy for the judges as well as the lawmakers because most of it is either written or interpreted in the dialectical fashion. In case of Hindu and other traditions like us, it's very complicated. So, like, contrary to popular perception, the rights of a deity were not first recognized in the Sabrimala judgment alone in 2016. They always used to happen even before 2016. I mean, I think even in the British era, there are judgments of high courts.
Yes.
The high courts came in the colonial era only. I think in the East India Company or both. I think East India Company. They came at that time. All of these high courts. They had these conceptions of, legal rights and of their deities, basically juridical rights of deities, juristic rights of deities. And these rights were always recognized. So it becomes essentially important that as these rights are emanating with time, we come up with better ideas and better solutions. Largely, what I see is that people generally do not, because they don't take it widely. And again, we have to link with this minoritarian tendency with the political way we deal with it. It's linked with that. It's linked with the feudal characteristic of politics that, you know what, you try to give leverage economically or politically to particular communities of any sorts or elites of any sorts and all of that. So it is related to with that. I largely think the law is either mute or the law is in a hindsight situation to be implemented in that way. That is why it is done in that way. It's a hindsight situation largely. In my view, people can refer to colonial issues and all of that, but I think it's more of a hindsight issue when we became, for example, people say, अरे नहीं ये तो दूसरों के जजमेंट्स बड़ा इंटरप्रेट करते हैं कॉन्स्टिट्यूशनल लॉ में. I agree with it. मुझे भी कोई इंटरेस्ट नहीं है in comparative constitution. But my whole problem with that is people don't understand one thing, that even if the judgments of other countries are taken, why they are taken? Yes, colonial norms and their biases are definitely there. But not everywhere. For example, the 2017 Puttaswamy judgment on privacy, this concept of right to privacy being included as an absolute right under 21, I am fine with that. But what is the policy guideline to be given to the government if they came up with a law? Nothing specific. Okay, if you read the section by Honorable Justice D.Y. Chandrachud, you'll find the very voracious and interesting parts where he cites the Stanford Encyclopedia of Philosophy. He gives that, what in the West, only in America, UK, and Europe, these particular conceptions of privacy have come. So my whole issue here is you can only come up with an Indian conception or an Indian solution when you think of Indian realities. You can try to link it with Indian cultural philosophies or not. That's a different issue altogether. Some things might be legalized, something might not be legalized. It is a different matter altogether. But honest efforts aren't being needed. I mean, I know one judge who is very popular. I don't know why law students don't discuss. Justice Vinod Chandrapal. He was the judge for the Tokyo trials in the International Tribunal for the Far East. He completely.
I think there's a movie where Irfan Khan has played him.
In Netflix.
Yes.
On Netflix.
Yes.
Excellent show. So Irfan Khan was a great actor in my view.
He was an amazing actor. Yes.
Yeah. So some of the few in the so-called Bollywood, but yeah, main point is that Vinod Chandrapal basically inspires from Hindu jurisprudence. Now, if a person can do, why not others can even try to? But hota kya hai in India?
And more, he's doing it in an international context. It's not merely in an Indian context.
Yeah, he was the one of the first people who redefined the way international humanitarian law worked, because the Geneva Conventions had not come at that time. the 1949 Geneva Conventions, which are very popular, the 4 Geneva Conventions, and then the 1976 additional protocols 1 and 2. तो उस समय जब ये सब नहीं था, the war crimes and all of those were not recognized properly. बस अब I think कौन सा कन्वेंशन था, मॉन्टेविडियो था, नहीं, हेग कन्वेंशन था, द हेग कन्वेंशन ऑफ वॉर 1908, बस वही था, और एक 1919 का शायद था, 1918 और 1919 का, बट उतना ही था. And yet the interpretation by the judge is excellent. It's 800-700 page work. It's available on internet domain on archive.org, etc. People should read it. So जब एक व्यक्ति कर सकता है हिंदू jurisprudence में, Ambedkar made his mistakes, I agree. Lawmakers made their mistakes, I agree. But अब करो तो. I am just waiting for that time when people really think differently. Let's give a final example. But yeah, before you go ahead, I know I'm taking a little bit more.
Well,
just
absolutely.
One more point.
This is a fascinating conversation. I'd like for it to go on for a while. I just wanted to sort of... But you know, I'd love for you to complete that example. I also wanted to sort of posit this, and you are welcome to, you know, correct me and anything else, make your additional points if you'd like. But my understanding from, you know, the current situation around legal aspect is not that the Constitution itself is flawed, because however it is flawed, it can be amended, etc. But a lot of people go into the aspect of it being a colonial document, which, you know, given the times, it's fair, but the argument is made that we should junk it completely and come up with a new constitution, etc. My understanding is that it's more in the law schools that we need, in the jurisprudence and in the teaching and the interpretation of those laws, that we need you know, a more Indian, a more local, indigenous context. Is this something that you would agree with, or would you think that the Constitution itself is a document that needs to be, you know, reviewed and probably discarded and rewritten?
Okay, 3 things on this. First, if we say we are a sovereign country, which we are, we can come up with any other constitution, which is a different debate altogether.
Sure.
Number 2, the current constitution, it's a very long constitution. I can't comment on it stereotypically, but I'll generalize a little bit by stating that it has a post-colonial policy limbo. Iska matlab kya hai? That despite the fact that you are not physically and politically colonized anymore, you have certain norms, legal norms, which have affected the functioning and the premises of the constitution. जैसे आपने बोला minoritarian state, कहाँ से आया ये feudalization? ये ब्रिटिश era से है. Okay, तो ये वहीं से आया. अब वो पोस्ट कॉलोनियल है. इसका मतलब ये थोड़ी ना कि आपका ब्लेम नहीं है, आपने कोई चेंज नहीं किया पॉलिसी में, समवेयर डाउन द लाइन यू आर आल्सो रिस्पांसिबल. बट आई वुड से इट्स अ पोस्ट कॉलोनियल बैगेज की एक पॉलिसी लिम्बो है कि आपने कुछ नॉर्म्स जो हैं इतने कंफ्यूज्ड रखे हैं दैट देयर वर अ लॉट ऑफ इश्यूज. नंबर 3, it needs severe reforms, and the constitution is not simple and utterly complicated for no reason. यहाँ पे I would say it is a post-colonial policy limbo plus over a very bad understanding of legal theory. अब उसमें एक पॉइंट है which I wish to make है कि जो legal theory की understanding है हमारे यहाँ, of course people claim that common law is Christian by nature. Of course it will be Christian from a monarchy which is Britain, but I know countries which use common law which are not colonial and all of that anymore, but they actually use common law in a better way. See, regardless of any Abrahamic religion's influence or not, which is the OET, which is being proposed by a very, I'll say it very humbly. So Advocate JSD in his interesting book India That Is Bharat argues about OET, which is ontology, epistemology, theology. अब उसमें क्या है? तो obvious सी बात है कि भैया from the canon law understanding and all of that, common law came in, and the theological context will always be given to justify anything. वो बहुत obvious सी बात है, which is fine, he is correct. But to say that common law itself is based on Christianity is like saying that democracy was based on Christianity, which is not true.
Not true.
Liberal democracy, we can say it's based on liberalism and Christianity, because Enlightenment and Protestantism, all of that is linked here, because वो एक अलग ही issue है. But for this, I think that common law now it is as it is. It's just our hindsight of legal skills. As I told you, any constitution or law can be used in hindsight by creating such internal jurisprudential norms and biases, which is confirmation bias, etc., to basically subvert the system. Now, it doesn't mean that you should not do reforms. I am all advocating for them. I am just not going to say scrapping it. I'm saying incremental reforms. I'm saying ठीक है बहुत बड़ा constitution है, simple होना चाहिए. Many legal questions should be sorted out. I'm not going to pull up that conspiracy theory which people used to say relating with Article 147 that we are still a Commonwealth country, therefore a colony. No, we are not. Only Australia states a little bit allegiance to the majesty of UK. वो भी अलग issue है. But we are even a part of the Commonwealth. We are not. We are a completely sovereign country.
Yes.
Our problem is that yes, there is some colonial aspect, but वो उतना नहीं है कि वो किया जाए. I think it is more about norm creation
like
and norm perpetuation.
So there was this funny incident. I think you may have heard of it, where in France, women were forbidden to wear pants since I think in the 1700s, and they changed that law somewhere in the late 2000s. So they just didn't pay attention to it. It's not like that made wearing pants illegal. I mean, technically, sure, but it's not like it had any effect on the actual implementation of legality. So that's
yeah. It's about norm creation. It's about how norms are created, what biases are aligned with it. वो question करना चाहिए. जैसे देखिए, the reason why, if you see Hindu Marriage Act, for example, I mean, of course, it should be reformed very heavily. But even in Section 2, when a Hindu is defined, there's no definition basically. It's a classification. कि Hindu मतलब कौन? Those who follow the Hindu faith, Buddhist, Sikh, Lingayat, Brahmo Samaj, etc. उनको माना गया within Section 2 of the Hindu Marriage Act. That's the simplest understanding anyone can have.
But that was the time of the race construct, so it's understandable, right? They just viewed it as more of a race issue than anything.
Hindu Marriage Act is a post-colonial law, बस. ये तो Ambedkar का है.
True, but I mean, even V.D. Savarkar and I think Swami Vivekanand have also used it in that context. So,
yeah, because at that time when the British census happened, they had a very rigid understanding of all of our communities. Sure. So वो census से वो आया. It is also linked with the way our reservation policy is made.
It's an understandably simplistic understanding because it's an outside perspective. It's quite understandable in that sense that it would be a rigid understanding because they need to define us in their terms. Sure.
Yeah, and of course, when you use law in a way that you can ossify anyone, you can ossify the economics, you can ossify the way of life, you can ossify anything. यही तो problem है कि you create a norm using particular things and then you don't review them. I think what should be the problem is the norm perpetuation and the norm creation issue.
Right. That's very
Interpret तो आप कुछ भी कर लो. And that's very interesting. I mean, I don't know why people ignore it. They think, जैसे एक simple सी चीज़ अब खत्म करता हूँ. People think that, you know what, अच्छा ठीक है, one X community is offended by some action on social media. I know the free speech argument, Brandenburg versus Ohio, etc. I'm not getting on that. But even if we look at the applicability of saying, you know what, you want to sue somebody and you want to send somebody to jail. First of all, are you supporting the top-down approach of how are you wanting to stereotype your community understanding? Because that is exactly what happened in the the act on grooming against women. People call it love jihad. I think legally it should be called as grooming. Which is force. It is grooming. It is grooming, and the problem with the law was that there are certain things which are based on a certain parallels of understanding. Of course, it can help you in alleviating from the situation, but somewhere down the line, it does not pass the test of not being arbitrary.
I think Nikhil Mehra had a discussion on the Charvak podcast where he laid out how utterly terrible that bill was.
Yes, the ordinance at that time, and then it was passed as a bill.
It was very stereotypical in a sense. It was based on a social understanding rather than a legal framework.
Exactly. I mean, I completely blame the lawmakers and not the chief minister. Chief minister क्या ही करेंगे? But the lawyers थे, they are very poorly trained in Hinduism. Their understanding is that Hinduism is a collective. मतलब इन द सेंस कि उन्होंने पता नहीं क्या था, वो एक कलेक्टिव अंडरस्टैंडिंग दी थी हिंदुइज्म को, विच वाज नॉट ओके, विच इज वेरी वेरी प्रॉब्लमेटिक, और यू कुड हैव डायरेक्टेड इन अदर वेज। बट वही है कि देयर इज नो क्रिएटिविटी। ये यहाँ पे कॉलोनियल बायस है, यस, दैट यू टेक अवे द नॉर्म्स, you use it for power or you use it for any other reasons, but वो post colonial baggage आज भी है, so you are not able to autonomize and come up with something which is yours, which is something which is more pragmatic.
Is there a law, since we're speaking of grooming in this case, is there a law that the UK has passed about the grooming gangs? I know it's been an issue for several years. I'm pretty sure that it's been mentioned even a decade ago that this was something that was happening, and there were only newspaper articles. But right now, I think the cry has gotten a little louder. That is there a law in the UK that deals with this, or no?
Not sure about it, but could be. But there are issues of forced conversions and forced marriages in UK, where certain people, I think, in terms of immigration affairs, which is to say that, you know what, taking some fake political, taking some political asylum and whatnot. Many people do that in UK. And yeah, I mean, it's possible.
No, there's a
I'm
lot
not
of
sure about the law,
literature on
but yeah.
grooming gangs. I'm not sure about the legal aspect. So, you know, that could have been, since we keep citing American and British law, I think that would at least offer some sort of understanding of the norm and how to frame a legal approach to this that is better than the current one, which is really pretty terrible.
Exactly. Definitely. I mean, I think what we need is that we need to understand how to implement it in the first place, number one, and number two, how our norms work. The same problem is in the IPC and the CRPC. Severe problem. They are genuine issues. Okay, so colonial baggage है, but हमने भी तो बढ़ाया। क्या कर रहे थे? That's what I'm trying to say. I mean, अब ठीक है, अब तो ठीक कर लो. I'm just saying that. I'm not saying even, you know, what you can't, but I'm just saying अब तो कर लो. So that's it. I mean, that's my only proposition. हाँ, colonial bias है, but उतना नहीं है जितना लोग समझते हैं.
Right.
क्वांटिफाई नहीं कर सकते आप हर चीज को. अब इकोनॉमिकली कितना ही करोगे, ठीक है, लेकिन क्वालिफाइंग वाइज, I mean, कितना ही करोगे. So it depends on that. But yeah, it's a Pandora box. Yeah, now you continue.
All right. Will you just segue shortly towards the report that he wrote? And since you mentioned norms, that seemed appropriate because, you know, that's something you've mentioned in the document as well. So I'm just going to pull that up for the audience again. And so it's a really large document. And these are smaller portions of, you know, thankfully there are smaller portions that you can go through as in article form. So could you take us through the primacy of norms in case conflict of norms? So this part is something that would we can segue into from our previous discussion.
Sure, just let me open this and I'll just then show you up from my side. Just give me a minute. Just opening it for just reference because it's been months and it just helps to skim out. So see, in this report which we had gone through and worked on, my colleague Bhavna and I had worked, I'll be very honest. I think you're referring to 3.1, right?
Yes.
Just a minute, I think I'm just getting on the chapter because it's better to interpret and speak.
Page 18 to 20.
Thank you so much for that. Yeah, so see, if you talk about the legal aspect of it, very simply speaking, so क्या होता है यहाँ पे? As I had stated, when there's a conflict of norms in place, the question is which norm should be given importance. ठीक है? Now, Article 103 of the UN Charter is very clear that any obligation under an international agreement, अब जैसे मान लीजिए कोई ट्रीटी होती है या कोई कन्वेंशन हुआ कंट्रीज के बीच में, MOU नहीं होता, MOU इतना enforceable नहीं होता है, so we are not going to talk about MOU or all of that, but treaties are international agreements in that sense. तो जैसे वहां पे होता है, what generally happens is that the obligations under the UN Charter are prima facie important. आप उनको violate नहीं कर सकते. You have to interpret in a way. Okay? For example, you can't have a treaty which derogates the sovereignty of any other country. So Article 2 आ जाता है UN Charter का sovereign equality. something you can't violate Article 51 for example. Also you can say nahi, collective self defense or collective security ka jo issue hai, which is Article 5 of the North Atlantic Treaty also, based on which NATO was formed. The same problem, that what, no problem kya, norm hai, that what, you can't just go against the UN Charter in that sense. But again, it is subject to interpretation. और यहाँ पे बहुत इंटरेस्टिंग गेम चल रहा है इस समय इंटरनेशनल लेवल पे. तो क्या होता है that there's a concept of jus cogens or ius cogens, as we say. What is ius cogens? In the Vienna Convention on the Law of Treaties, ius cogens are peremptory norms. What is peremptory norms? Essay norms in customary international law, which are just not, violable at all. You can't violate them at all. And they have a very specific value of implementation. But it again depends which is just ius cogens or not. Okay. So in various lawyers in the West in the 18th century claimed that, there are certain norms from which no derogation is permitted. The same happened in the International Criminal Tribunal related to Yugoslavia post Joseph Tito. If you want to read the Vienna Convention, you can read Article 53 and 64, wherein it is very very clear कि अगर कोई peremptory norm किसी treaty के conflict में आ गया, ठीक है, then the existing treaty would be subject to abrogation. हटा दो उसको. The treaty will not be implementable at all. Sure. So ये बड़ा interesting होता है that you use certain norms to impose. So वो होता है, I agree. But मैं कह रहा हूँ, if India wants to get to the next level, it should say, देखो भैया, मैं जिस कोजेंस अपने ही तरीके से क्रिएट करूंगा, धीरे धीरे करके स्टेट प्रैक्टिस बन जाएगी, धीरे धीरे करके CIL बन जाएगा, धीरे धीरे करके उस कोजेंस बना देंगे.
Genuinely helpful, right? We are in a state of arbitrariness, and like you said, we are a confused state, so that's absolutely necessary to codify it as.
And how will it be interesting? How will it be interesting? You can use it against China, you can use it against Pakistan, you can even sometimes use it against the United States. I don't care. So you can influence jus cogens. ये international law का question है, so I'm not talking about domestic affairs. इतना domestic पे apply भी नहीं होता, because I mean इतना नहीं apply होता international law जितना लोग कहते हैं. But वही है. तो if you are asking about case conflict of norms, this is what it is. ये similar है जैसे international, so public international law is also called as international constitutional law. यही reason है क्यों कहा जाता है. So it's very interesting. Then thanks you that you asked for it. So yeah.
Sure. Now let's go on to the aspect about sovereignty that you mentioned.
You can tell me the page number also.
I think that's 21 and 22. I actually really enjoyed reading that. And I would suggest, I will certainly link it down in the description box below, but I would suggest all the viewers to go and actually see what is written in that paper. So you've mentioned 4 traditional sovereignty. So this is a 4, I think, article, or I don't know how it's codified. It's page 20, I think 20 to 22, traditional sovereignty in customary international law. So the special origin of sovereignty and concepts of traditional sovereignty, etc.
Yeah, so there are certain non-exhaustive features of sovereignty. And traditional sovereignty हम क्यों कहते हैं? Because despite coloniality or not, traditional sovereignty है. अब वो है European because somebody created it. अब मैं उस डिबेट में नहीं पढ़ने वाला हूँ that you know what, Chanakya created it. No, Chanakya had a theory of war, he had a theory of statecraft. वो सब अलग issues है. But आप ये कर सकते हो कि past या present में आप जो बना रहे हो, you can come, but वो एक अलग debate है. So let's get on the main point right away. Now, interestingly, if you see this, first point is sovereignty is equal and must not be undermined under international law, whether of any recognized state. मतलब, first of all, sovereignty should not be undermined by any way. So it is related to the pre-Second World War and pre-First World War times in Europe, where many conflicts used to happen, and sovereignty was a juggling ball for people. They used to treat it like a joke. So at that time, from those times, the notion of sovereignty was transformed in that way, which is for European-style states. In fact, nation states, as argued by JSD, which he is correct here, are based on the conception of European states, because of the League of Nations Covenant, and you can refer to Article 21 of the League of Nations Covenant. Very interesting, you can read it. यहाँ पे he is absolutely correct. So nation states are a European idea. The Siamese had to change to Thailand. The Chinese, also the Qing dynasty was already breaking, and it converted into Republic of China, and of course then People's Republic of China and Republic of China, which is Taiwan right now, and the main Xi Jinping China. So sovereignty is based on that. वो बहुत basic understanding है, सब जानते हैं, and it is a common understanding even in other civilizations, even others. We also have that. Then the degree of influence of sovereign equality in international organizations differs from organizations to organizations. इसका मतलब, if WTO, World Trade Organization, handles with matters of trade and economic law, it will handle sovereignty issues related to trade and economics will be dealt through WTO based on the mandate of WTO. For health emergencies and health issues, which organization will you go to? WHO. For telecommunication, provided that you have ratified the communication Telegraph Convention, you will go to ITU, which is the International Telecommunication Union. For labor laws, you will go to the International Labour Organization. For if you are regional level पे है, तो European Union के member हैं, then you have to abide by the EU's treaties, such as the Maastricht Treaty, the Lisbon Treaty, and others. If you're a part of the Council of Europe, which is a human rights
play into these? How does a state sovereignty play into these?
Correct. So a state sovereignty very directly plays into it when countries say, on certain matters, of course we have sovereign equality, but on certain matters where we claim that we have a sovereign right to challenge certain things, we will also give away certain aspect of our sovereignty to international organization in certain aspects of policy.
Right.
It's a bargain between the international body and a sovereign state. There are always reservations which countries give when they ratify to a treaty or a convention. India also does it. Sure. India has India has a very interesting reservation to the ICJ statute as far as jurisdiction is concerned. Very, very interesting. Just awesome. I mean, I love the legal interpretation of it. So yeah, I mean, you can
so what is that? What is the legal?
I think it was about, I think if I'm right, it was about India ICJ reservation. I'll just let you know right away. So a country which is a party to the ICJ statute and the UN Charter has to recognize the jurisdiction of the court. Okay. On 27 September 2019, under the ministership of Jaishankar ji, what happened was that as far as conformity with Article 36, paragraph 2 of the statute of the ICJ is concerned, there are nine reservations which have been given on the acceptance of jurisdiction of the ICJ. तो मतलब हम हर मामला ICJ के अंदर नहीं जा सकता. जैसे I think when some case happened, I don't know निर्भया था या कौन सा था, some rape case happened. एक महान वकील साहब थे from I don't know which high court or supreme court, इससे ICJ को लेटर लिख रहे हैं, आप ले लीजिए मामला. वो क्यों लेंगे भाई?
Right.
ये वो क्यों लेंगे? हो ही नहीं सकता. ऐसे नहीं होता. You are not even a party. An individual can't file an application in the ICJ. Only countries and international organizations, sovereign state and international organizations. Simple. अगर United Nations करना कर सकता, but करता नहीं है. Generally, you don't find, or the UNSC directs for an advisory opinion. So either contentious case or advisory opinion.
Sure.
So simple भाषा में, the interesting amendments which India did was, I'll tell you. So number one is just let me share with you. This is in your private chat. Please go ahead, and you can read the interesting thing. In section 10, India has reservations on disputes related to the status of its territory or the modification or delimitation of its frontiers or any other matter concerning boundaries. Okay, now you can relate it to the Kashmir issue.
Okay, wait, I haven't really received it yet. I'm not sure. Well, you've sent it on my Twitter DM.
On your no, I have DM'd you on your StreamYard DM.
Ah, I see. Sorry.
Yeah. So number 10, you can understand, very commonsensical. Okay. But also one interesting amendment which was done was that, okay, you go to number 6, 7, and 8. 10 तो बहुत obvious है. हाँ, 6, 7 and 8. Very good. Very good. Keep sharing it. Number 6, what it is written. Disputes where the jurisdiction of the court is or may be founded on the basis of a treaty concluded under the auspices of the League of Nations, unless the government of India specially agree to jurisdiction in each case. ठीक, विच इज वेरी इंटरेस्टिंग कि आप कैसे किसी के jurisdiction को एक्सेप्ट कर रहे हैं. नंबर 7 इज मोस्ट इंटरेस्टिंग. आई लव द लैंग्वेज. Dispute concerning the interpretation or application of a multilateral treaty. मतलब ऐसी multilateral treaty जिसमें इंडिया पार्टी ही नहीं है. It can be any human rights convention.
That's exactly what I was going to come to, actually.
So let me complete.
We don't actually pursue this, right? We have this jurisdiction reservation in place.
So let me complete now. And disputes concerning the interpretation or application of a multilateral treaty to which India is a party, unless all party. क्या मतलब हुआ? Multilateral treaty जो है, इंडिया की कंडीशन ये है कि अगर हम उसके पार्टी हैं कि नहीं, इससे कोई मतलब नहीं है. यदि आप उस मल्टीलैटरल ट्रीटी को हम पे अप्लाई करके आईसीजे में हमको स्यू करना चाहते हो, then it can only happen, and the only one condition is all the parties to the multilateral treaty are also parties to the case before the court, which means सबको करना पड़ेगा, or the government of India especially agrees to jurisdiction. This is such a hardcore legal argument कि कोई भी इंडिया के खिलाफ फाइल नहीं कर पाएगा. भाई, there are 160 plus parties in many conventions. तुम सबको कहोगे भैया सब कर लो, इंडिया ने कहा ठीक है, let's do some diplomatic bargain, एक को निकाल दो, खत्म. तो it's very interesting. And number 8 तो भाई, I mean disputes with the government of any state which on the date of application to bring a dispute before the court, the government of India has no diplomatic relations or which have been recognized as the government of India. ठीक है. So reservations are based on those regard. It is very interesting. It's a very nice phenomena. India has, so there are certain Indian lawyers who have really done well in this. I think NLU Delhi की team होगी या किसने थी जिसने किया था for the Jadhav case. But this one is excellent. I mean, so there are some people who are.
So can you just, for the simplification for our audiences, can you give us a couple of just one example for each point? Just one example for each point, not where it's been applied, but what it can prevent or how it can be applied.
For 7, I have given you कि जैसे कोई human rights treaty है.
That's understandable. I think.
That's understandable. Yeah, so the number 6 is very simple कि जैसे कि मान लीजिए कोई डिस्प्यूट आ गया जिसमें एक ट्रीटी के आधार पर जो लीग ऑफ नेशंस के ऑस्पिशियस में बनाई गई है, ट्रीटी ऑफ वर्सेल्स एंड अदर्स, उसके आधार पर आईसीजे का जुरिस्डिक्शन तैयार किया गया, बिकॉज द आईसीजे इज यूजुअली कंसिडर्ड एज अ कंटिन्यूएशन और सक्सेसर टू द परमानेंट कोर्ट ऑफ इंटरनेशनल जस्टिस इन सर्टेन वेज, जो लीग ऑफ नेशंस के समय था. तो यद्यपि उस ट्रीटी के एप्लीकेबल होने की स्थिति बनती है, उस रिगार्ड में रिजर्वेशंस हैं कि जब तक भारत सरकार सहमति नहीं देती है उस पर्टिकुलर जुरिस्डिक्शन को, तब तक वो ट्रीटी मान्य नहीं है, जुरिस्डिक्शन मान्य नहीं है. That's the simplest understanding I can give on number 6.
Sure. My question is, has anything happened that kind of caused us to encode this? I know most of these are preemptive measures. I'm just wondering if, how our disputes, where it's on the basis of a treaty concluded under the League of Nations, is that something commonly that comes up commonly in ICJ? Not necessarily with regards to India, but is that something?
Depends. Used to happen in the Cold War era. अब नहीं होता.
Sure.
अब एक दो होंगे, अब नहीं होगा.
We just have let go of those things, all right.
And that too between European nations.
Right.
यूरोपियन नेशंस में. अब नहीं, हमारे यहाँ कुछ नहीं है. हमारा इशू इतना नहीं है आईसीजे में. पाकिस्तान से था, पोर्टुगीज से था, इतना बड़ा इशू नहीं है. अब तो कोई आने वाला भी नहीं. I mean, but yeah, your number 8 you're saying, right? So disputes with the government of any state with which on the date of application government of any state, मतलब कोई सरकार जो बाहर है, we are not talking about राज्य सरकार.
Of course.
So dispute with the government of any state with which on the date of the application to bring a dispute before the court, the government of India has no diplomatic relations, और मतलब क्या हुआ, जैसे मान लीजिए कोई XY स्टेट है सरकार के ना उनसे डिप्लोमेटिक संबंध हैं, ना उन सरकार की जो स्वायत्ता है उसको भारत सरकार ने स्वीकृति दी है. You don't even recognize if something is a sovereign country. Why we would even take their matter, even if they're a UN
I
member?
think is one of them.
Bas.
Yeah.
हाँ. So that is the illustrated understanding I wish to give you. It's very interesting, and this is what is something unique to me. कि हमारे यहाँ लोग हैं करने के लिए नॉर्म क्रिएशन और नॉर्म अप्रिसिएशन. जैसे कि मैरीटाइम लॉज हमारे बहुत कोलोनियल रहे हैं, सब पुराने टाइम के, बट वही है कि नया किया जा सकता है. जैसे इट यूज्ड टू बी सेड दैट व्हाट द ब्रिटिश समहाउ ब्लॉक्ड आवर सेलर्स in the early times. They did block our sailors from former empires and whatnot. कोई डाउट नहीं मुझे, लेकिन आप तो मैरीटाइम पॉलिसी नहीं बना सकते हो ना. आई वांट इंडिविजुअल्स हु आर पैशनेट अबाउट. मैं तो आज भी कह रहा हूँ, मराठा हिस्ट्री आप पढ़ते हैं, मैरीटाइम हिस्ट्री, मराठा आर अ वेरी बिग रोल टू प्ले, स्पेशली शिवाजी. आप अगर सजेस्ट करना चाहते हैं मैरीटाइम पॉलिसी, प्लीज गो अहेड. Just see how it practically involves. So, yeah, you can go ahead fast. I think we have crossed a lot of time. So,
we have. I'm sorry. I have. See, you left us on a cliffhanger the last time, and I know we've discussed a little of it offline. That's one thing that I want to discuss, but we'll keep it last. I just have one other question that it need not be lengthy. I just want an answer, and this is something that struck me, that we have a sedition law that is much reviled at this time, right? It is definitely a colonial vestige. Sedition cannot apply to a sovereign state, is what I see. For the most part, it's part of a colonial state that sedition applies to. Now, however, it is applied very often with regards to national security, which in the US would simply be applied under treason. Do we have laws that codify treason, and do we have a law that actually states even the word treason? Because I have not really come across any cases that discuss this.
So interestingly, the reason why sedition law is justified in India is because of law and order problem, very simply speaking.
So
otherwise,
why would it be applicable the same way?
I think that is subject to interpretation, because the American law understanding is something which would really differ here. They have a clear doctrinal institutional understanding. Our understanding is not like that. So it depends how we define treason and other things. These are, as I had said, unfortunately, it seems repetitive, but it's more like, it's like Section 295A of the IPC or something like that. So it is like that. How do you deal with provisions which make sense? And I have no issues with sedition as a provision unless and until it is basically used in an arbitrary way. Like, for example, exactly. Sadly, it is. Yeah. For example, it applies to even I'd say other matters of criminality and others. But you know what? I think what we need is that if we are saying that national security is being affected, and evidentiary values have to be, we have to reform the Evidence Act very, very seriously. We have to also reform the way evidence procedure is dealt with, how we present the evidence as the state. You just can't come with anything. Arrest कर लो, दे दो कुछ भी, चूरन पहना दो, ऐसा नहीं होता. You चूरन नहीं देते हो, proper evidence दीजिए, चाहे circumstantial हो चाहे primary हो, something which makes sense. Whether state lawyers or private lawyers or anything. I mean,
see, again, my question is because it's not that obviously even our Supreme Court, our foremost authority on this, has applied the sedition law, and we've seen certain cases go up to the Supreme Court to discuss this. Now, when it comes to sedition as a matter, what the evidence provided and the way of interpretation remains arbitrary. Sure that we don't have an institutionalized understanding of it, but then sedition it's not even sedition means that you would secede, and you would probably be causing issues to the to the side. So now treason would affect national security typically, like that's how, and to codify treason you would have to affect national security, and the evidence presented and the interpretation would have to define would have to be along with the definition of how it's affecting national security and how it is treasonous and, selling us out, or however it is. Now, sedition can be applied to literally, like you said, law and order issues, right? The smallest of issues, whether it's whether we see evidence of a different
so
nation.
for example, if you deal with a problem and you claim seditious, it is based on what is the circumstance. Now, yes, there are certain public policy issues in which people, if they do certain things, they cause security issues. And yes, on that, I think there should be a quick mechanism to not allow any bail and all of that. There are certain offenses in that sense, but I think uh, I think it is about the efficacy of the state in the sense how, at the level of the districts and states, basically enforcement of law happens. We rarely study properly the role of districts here. We think, what it's all about high court and, what. Nahi, bhaiya, judicial magistrate se bhi kahani shuru hoti hai. And that is something which is very interesting and important. So I think that's a part of our federalism in very interesting ways, and we can use it. See, we need a strong union government, no doubt, but we also need that. So I think in that case,
Yeah, we are a very
really
large
helps.
country and we need that support.
Yeah. So I think in that sense
Right.
it works.
Now, let us just move on to the last question that we have, that you actually left us in suspense with, about the Ministry of Cooperation that you mentioned the last time.
Okay, so since I did leave you in suspense, I will try to do it again. But see, the Ministry of Cooperation is a very interesting ministry on administrative matters. Amit Shah is the current Home Minister. He's also the current Minister of Cooperation. It can actually do a lot of reforms in terms of cooperating with districts and cooperative societies. At an administrative level, it can suggest various things and do a lot. So, cooperative societies and cooperative institutions, housing societies, Amul, and all of those, they can play a great role in nation building. And I think, in several administrative reforms, it's like empowering the panchayats and connecting them with the union government properly, and they can play a great role.
Right.
So similarly, the union government has been excellent in delivering reforms on Swachhata and all of those because of the panchayats too. The role of the Panchayati Raj is very essential here, and the same I will say for therefore the cooperative societies and cooperative unions and all of those organizations. And so definitely this ministry is a great achievement, and I commend the government for this. I think a lot focus should be on this ministry, because the future is a strong union government with stronger district governments. State governments, in my view, can be vassals, but they have a role also. That's my view.
All right, I'm just going to simplify this for the viewers, or maybe exemplify it a little bit. Ministry of Cooperation, like Abhivardhan mentioned, we have cooperatives like Lijjat Papad, Amul, all of the Nandini in Karnataka. So all of these are often, state-run or state sponsored cooperatives that bring about economic sustainability to a local population. And they are very effective because they are sort of welfare-ish, but they do a lot of capital generation. So, for example, during the pandemic situation that hit us so hard in terms of economy, one people that were relatively unaffected were the dairy farmers, especially in and around Gujarat, who were supplying milk to Amul. Because what they did was, because the perishable milk would not be as much will not be seeing as much sales at that time, they converted a lot of it to milk powder. So that they still got paid for it, and there were still sales on what made sense for that time. But that sort of adjustment is something that was left to the cooperative society, that ensured that the people working for the cooperative were well taken care of. So it's once it's regulated, once it's under some sort of government supervision, it makes for a really great economic redistribution mechanism. So that's what I think you're saying, right?
Yeah, fair enough. I think you summarized it very simply, so I appreciate that.
All right. So, all right. Thank you so much, Abhivardhan. We've been talking for quite a while, so thank you so much for making the time for us. And see you soon again.
Definitely. And let us see. We'll discuss the Indo-Pacific and what should be an India-led approach to the Indo-Pacific, perhaps.
Absolutely, absolutely. I look forward to it. All right. See you again soon, Abhivardhan. Take care. Bye-bye.